Andy, just thanks for your assistance yesterday. Very much appreciated.
So I believe we're only waiting for Mr. Rasmussen. So we still have a few minutes.
Just a heads up that YouTube is live and kicking right now as well.
Good. Thank you, Mac. I've asked Mac to contact Mr. Rasmussen to ensure he's not having any technical difficulties.
He has joined.
Hello, can you hear me now?
Yes, we hear you.
Perfect, thank you.
There. Yeah.
Me and computers aren't always friendly with each other.
And we can now see you as well.
Yeah, I just took off the little clip on the top. I forgot about that.
Okay, is everyone ready to go? Okay, good. Good morning and welcome. My name is Sandy Roberts, and I'm chairing this panel of the Natural Resources Conservation Board to hear a review of the approval officer's denial decision RA22027 for Darcor Holsteins, Inc. Thank you to all parties for accommodating the board's request to hold this hearing today. Before we get further into the hearing, I want to take a moment to respectfully acknowledge that we are coming together online from the traditional lands of Treaties 6, 7, and 8. I recognize the many First Nations, Métis, and Inuit whose footsteps have marked these lands for centuries and who share a deep history with the land. To help you identify NRCB panel members and staff, our Zoom backgrounds have the NRCB logo. Additionally, panel members have a mountain background and staff have a beige background. I will now briefly introduce the NRCB panel and staff. For your reference, complete board member bios are on our NRCB website. When I introduce you, please wave your hand. Rich Smith. Rich joined the board as a part-time governance and tribunal member for a 4-year term beginning April 11th, 2003. His appointment follows a career with extensive experience in the livestock industry that includes 15 years with Alberta beef producers, with 13 of those years as executive director, 8 years working with the hog industry, and 16 years as an agricultural engineer with Alberta Agriculture and Irrigation. He also spent many years as a member of the NRCB's Policy Advisory Group and the NRCB Agricultural and Irrigation Technical Advisory Group. He has a Bachelor of Science in Agriculture and a Master of Science in Agricultural Engineering from the University of Alberta. Rich is a member of APEGA. Darren Stepanek. Darren joined the board as an acting tribunal member for a 3-year term effective April 11th, 2023. Darren has worked in the legal and resource management fields for over 30 years and served as the director of the Environmental Law Section of Alberta Justice and Solicitor General from 2009 to 2018. His experience includes management of environmental impact assessment reviews, involvement in development of environmental and resource management legislation, and representing the province at public interest hearings on major oil sands, power plants, and other projects. In addition to an LLB, Darren has a BSc and an MSc in renewable wildlife and rangeland resources. He was appointed a King's Counsel in 2020. I am Sandy Roberts. I'm an agricultural engineer and a member of APEGA. I was an approval officer with the NRCB until 2010, have been a municipal councillor for the town of Carstairs, and was an instructor at Olds College for 17 years. After 3 years as an acting NRCB board member, I joined the board as a governance member in October 2020. I've always been an active community volunteer and am currently a member of the Central Alberta Regional Assessment Review Board and the Intermunicipal Subdivision and Development Appeal Board for Carstairs, Didsbury, Sundre, and Cremona. Assisting the panel are Bill Kennedy. Bill is the board's general counsel, and Laura Friend. And Laura is our manager of board reviews. If you have technical difficulties during the hearing, please phone or text Ms. Friend and she will help you. Her number, which you may wish to write down, is 403-620-8294. Depending on the issue, we may have to pause the hearing until the technical difficulties are resolved and everyone is again fully connected. We have 2 staff members that will be providing the virtual on-screen document management. Sylvia Kaminsky. Hi, Sylvia. And Crystal Powers Sanford. Morning, Crystal. When you want a document shared on the screen, please clearly say the exhibit number and the PDF page number, and then give them a few moments to get the document loaded. I would like to introduce our Zoom host, Mac El Hakim with MNP. He will be overseeing all the technical matters related to this virtual hearing. Also present is court reporter Wendy Woodworth, and she will provide a transcript of today's hearing for the panel's use. Welcome, Ms. Woodworth. To assist Ms. Woodworth, during the hearing, we ask that you identify yourself and speak slowly and clearly so that our court reporter can ensure she gets the transcript right. Ms. Woodworth, please don't hesitate to interrupt if you're having difficulty hearing or keeping up if someone is speaking too quickly. The NRCB has also provided a live YouTube link on its website for members of the public to observe the proceedings. The link is on the NRCB's main website page. The recording will be saved on the NRCB's YouTube channel. If there are members of the media on our YouTube feed and you have a question regarding today's process, please contact Janet Harvey, NRCB Communications. She can be reached at the email address janet.harvey@nrcb.ca or by telephone at 780-720-2317. The purpose of this hearing is to review decision RA22027 dated February 9th, 2024, issued by Approval Officer Francisco Echegaray. The Confined Feeding Operation, or CFO, is located at Northeast 144723 west of the 4th Meridian in the County of Wetaskiwin. The Approval Officer denied application RA22027 due to the operation being inconsistent with the land use provisions of the County of Wetaskiwin's Municipal Development Plan, or MDP. A request for review, or RFR, was filed by Darcor Holsteins, Inc., which resulted in Board Decision RFR 2024-01. That decision set out the reasons and process for the review hearing we are conducting today. Your participation in this hearing is very important to the panel. We look forward to the information that you will be providing and recognize that our decision will have a significant impact on you. The process that we follow is inherently formal. This is a quasi-judicial proceeding, and so a certain level of formality is appropriate. However, we do try to minimize formality to the extent possible so that participants are comfortable presenting their information to the panel. The board encourages you to ask questions if you are unsure about the process or about when you are allowed to interject. Please do this at any point during the hearing. I'll do my best to answer your question or to direct Mr. Kennedy to help you out. If we need to take a short break so Mr. Kennedy can spend a few minutes to help you, that's fine as well. I'll now provide a brief overview of the process for the hearing. First, all parties will be registered. Then each participant will have an opportunity to address any preliminary matters they may have. We will then proceed with the evidentiary or direct evidence portion of this hearing. In this hearing, the board believes it's beneficial for the NRCB's field services to present their direct evidence first, followed by Darcor, and then the County of Wetaskiwin. When it is your turn to provide evidence, you will be affirmed by the court reporter. Once affirmed, any new written evidence that you want us to consider may be entered into the record on request. We'll then give you a chance to highlight or expand upon any points in your submission that you feel are particularly significant. After each party has presented their evidence, they will then be open to questions by the other parties, NRCB Field Services, and NRCB panel members and board counsel. Once questioning is complete, the party that presented evidence will have an opportunity to introduce redirect evidence. Essentially, what that means is we give you a chance to submit any further evidence or comments to address areas raised in the questions posed to you, where you believe there is some additional information that the panel should have. Once we've completed direct evidence and questioning, Darcor may provide rebuttal evidence. If rebuttal evidence is provided, the other parties will be given the opportunity to ask questions. Finally, each party will have an opportunity to provide closing oral argument, and Darcor will have the option to reply. Are there any questions regarding the process we intend to follow today? We'll be taking breaks during the day, including a lunch break. I'll try to pause in a natural spot, so we won't be setting specific times for breaks. As well, there will be a lunch break. We hope to be done by 4 p.m. today. Does anyone have a concern about this timeline? Okay, hearing none, we'll now register the participants. We'll start with field services. Ms. Vance, would you register yourself and your witnesses, please?
Sure. My name is Fiona Vance, and I am Chief Legal Officer Operations at the NRCB. And in that role, I act as counsel for field services and the approval officer in this hearing. With me today are Andy Cumming, who is Director of Field Services Applications at the NRCB, as well as Francisco Echegaray, who is the approval officer for the NRCB on this file.
Thank you, Ms. Vance. Next, Darcor Holstings, Inc. You're on mute, sir.
Just realized that. Sorry about that.
No problem.
Hi there. I'm Darren Rasmussen. I'm the owner and operator of Darcor Holsteins, and I guess the reason that we're all here today.
Thank you. County of Wetaskiwin.
Good morning, everyone. My name is Jeff Chipley. I am the Assistant Chief Administrative Officer with the County of Wetaskiwin, number 10, the municipality in which this proposal is located.
Thank you. Now, I don't see anyone else on my screen, but if I missed anyone eligible to participate. Are there any preliminary matters to address, whether they're procedural, legal, or other?
No.
Okay, I don't see anything there.
Madam Chair, it's Fiona Vance. I just would seek permission to make a very brief preliminary sort of opening statement prior to the witness testimony.
Certainly, Ms. Vance.
Would you like me to do that now?
Why don't we do it just prior to field services direct evidence?
Thank you.
Okay. The hearing exhibit list was prepared and posted on the NRCB website for all parties to reference. Document manager, would you please put up the exhibit list? Thank you. I propose that we adopt the hearing exhibit list, which includes the relevant documents before the panel. Are there any objections to adopting the exhibit list?
None from field services.
No, none.
Okay, thank you. Hearing none, it is adopted. So we'll now move on to the evidentiary portion of the hearing. I would like to remind participants that it is important that presentations remain focused on the objective of responding to the core issues identified in Board Decision RFR 2024-01, as this will be the focus of the panel's decision following the hearing. Ms. Vance, I think now is a good time for your preliminary comments.
Thank you. And I promise I will be very brief. Just two small comments. First, our understanding of the scope of review, as you just alluded to, is that set out by the board in its RFR decision. At PDF page 6 of that decision, which is Exhibit 9, the board does refer to considerations related to MDP land use provisions and inconsistencies, and that is the scope that we have prepared for today. Second, in terms of position, I just wanted to be clear that the NRCB Field Services takes no position on remedy or outcome of the hearing today. As the decision maker whose decision is being reviewed and potentially could be sent back, it is appropriate that the approval officer in particular remain neutral on the merits of this review. If there are questions that come up relating to fairness or jurisdiction or clarity of the record, we may take a position or make arguments on that. However, otherwise, we take no position on whether the board should exercise its discretion under Section 25 sub 4 sub G of the Agricultural Operation Practices Act or not. I don't think there's any dispute that the approval officer did what the legislation required him to do. Those are my brief opening comments. Is the panel ready for me to go into direct evidence?
Yes, we are, Ms. Vance. Please continue. But before the direct evidence, we'll need to affirm your witnesses. So will Mr. Etchegary and perhaps Mr. Cumming need to be affirmed?
Thank you. And I was wondering, I think you're ahead of me on this. I was wondering if it would be suitable for the panel if my two witnesses were seated as together as two witnesses at once rather than one and then the other.
I think that the panel would agree with that, Ms. Vance, because some of the questions might be more suitable to one or the other as we go through this. So certainly.
Thank you.
Okay, Ms. Woodworth, would you please affirm these two witnesses?
Mr. Andy Cumming and Francisco Etchegary, Gary, do you solemnly affirm that the evidence you're about to give will be to the best of your knowledge?
I do.
And Mr. Cumming, do you solemnly affirm that the evidence you're about to give in this proceedings will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay, Ms. Vance, please proceed with your direct evidence.
Thank you. The decision summary and technical document from the approval officer, Francisco Etchegary, speak for themselves. Accordingly, I'm not planning to ask either him or Mr. Cumming questions in chief today, so there will be no direct evidence as such. However, both my witnesses are available and happy to answer any questions that any of the parties or the panel might ask as outlined in the order of proceedings.
All right, thank you. Thank you, Ms. Vance. So we'll then jump to the questions. And Mr. Rasmussen, you're on first for any questions you may have of field services.
Okay, thank you. These questions will all be for Mr. Echegaray. And if I could just confirm a few things with him, please. Back when this filing was initially posted in the newspapers, you received a number of letters, I believe, in opposition to this application. Would you confirm for me, please, that Mrs. Lynn Carwell was the author of one of the letters?
Yes, she was.
Is it fair to say that she was the only one actually that had multiple letters?
He did send multiple letters, but there are other people that might have secondary letters, maybe. But for sure, she did have multiple letters.
Yeah. I'm not sure how to put this as a question, but you do forward me every, sorry, I'm getting a notification of an unstable internet connection. So I'm sorry if something pops out here on me. You do send a copy of all of the letters to the applicant, correct?
To you, yes. Yeah.
Okay, correct. Did Councillor Carwell claim directly affected status in her letter?
She did.
Was there also a letter from her daughter, Kimberly Carwell?
Yes, yes.
Did this Kimberly also claim directly affected status?
Yes.
Was there a time later in the procedures where I contacted you with some concern as to that letter as far as residency requirements go?
Yeah, you a few times we talked, and you said that they were out of the area to be considered directly affected party, and also her daughter, Ms. Kim Cadwell, that actually she doesn't officially live at the residence. Yes.
Correct. Okay. Did and just for the record, I'm sure we all know, but when those letters are sent to me, they're complete with two exceptions. One is that the signature line is redacted, and the other is that the physical address is redacted. Is that correct?
I didn't hear the full question, but yeah, the redaction covers the signature and the address. You're right.
Yeah. Now, without asking you what the address that Kimberly Carwell submitted, would you be able to confirm that she used her mother's address in an attempt?
Yes, she did.
Okay.
Yeah.
Did you ever have an opportunity to talk to her and tell her that she would have to prove that address?
I did phone her, and I talked to her and asked her, and she gave me detail that she spent a lot of time at the residence, especially in the summer.
Did she withdraw her request for directly affected status at that point?
No.
Okay, but that it was proven later on that that neither of those qualified for that status.
You're right. So I didn't have to determine on the daughter specifically. She lived at the residence, but because both of them were outside the radius, they were automatically outside the directly affected party radius.
Okay, thank you. That's all the questions about the letters. the application itself, there's just something I'd like you to confirm for everybody, please. This has been quite obviously in process for a very, very long time. And would you just confirm that the application as it sits before us is absolutely unchanged from day one?
Yes, yeah. You submitted it, the part one, the initial one in November, and then the rest of part two in December, and it hasn't changed. Yeah.
Okay, thank you. And just to confirm, I'm sure most everybody's read, but environmentally speaking, strictly now and within your AOPA rules, with the exception of compliance with the county MDP, you have no concerns with the application, is that correct?
That's absolutely right. So in the decision summary in section 6, we say AOPA requirement, and it meets all the AOPA requirement with the exception of the meeting the County of Wetaskiwin municipal development plans.
Okay, thank you. You, of course, are the contact person when people call with questions about this application and concerns. Councillor Carwell, can you confirm that she has called you multiple times?
Yes, she did.
And has this continued on through all stages of this process?
After last year, we had another decision about your application. I have to I determined it was canceled and abandoned. And then after that, when we had a hearing and the board decided that operation stays, the permit stays, then she phoned the office. I wasn't there at the moment, so one of my colleagues took a couple of those phone calls from her. So she did call asking about the future and please come to see how close her house is to the lake and how close your operation is to the lake.
Okay. That's actually all the questions that I have for you. Thank you. And actually, I don't have any more questions for field services in general at this point. Thank you.
Okay, thank you, Mr. Rasmussen. The county, Mr. Chipley, do you have any questions for field services?
Thank you very much, Madam Chair. I just have a couple of quick questions for field services. Probably Mr. Etchegary will probably be the best one to answer these. The first question is, Mr. Etchegary, in terms of a response from the County of Wetaskiwin, can you confirm that the only correspondence that you received as a result of the application from the County of Wetaskiwin was our correspondence dated February 8th, 2023?
I did receive that one. However, prior to, and I can't remember the date now, I received a question about the application regarding the animal numbers. And comparing the animal numbers of hogs to the dairy operation. And that was, can't remember, it was maybe November 2022.
Yeah, no, and just as a follow-up to that, if I may, Madam Chair, with those questions that were asked in November of 2022, I believe that was done by Mr. Jarvis Grant, our Senior Development Officer. We had asked a question about animal units. At that time, could you recall if the County of Wetaskiwin asked a question as to the perspective of NRCB Field Services as to whether they viewed this as a new CFO application or an amendment/expansion of that CFO application?
I can't recall it that specific, but I think for what I remember, they were trying to see if it was an expansion according to the animal numbers. That's what I recall, but I could have access to the letter if you need me to answer it.
And if I may, just one final question, Madam Chair. With respect to the correspondence that was sent by Mrs. Carwell. At any time were any of those correspondences on County of Wetaskiwin letterhead or referred to an opinion of the County of Wetaskiwin versus Mrs. Carwell identifying herself as a private citizen?
No, the written correspondence. She always sent them as private citizens.
Thank you very much, Mr. Etchegaray. I have no further questions, Madam Chair.
Thank you, Mr. Chipley. So now board staff, and we'll start with Mr. Stepanek. Or sorry, board panel.
Good morning, everyone. The County of Wetaskiwin response to the referral of the application notes that there is an expired intermunicipal development plan between the county and the city of Wetaskiwin. The plan makes specific reference to development around Coal Lake as the main water supply for the city, and includes a section entitled Protecting the City's Water Supply that directs the county to examine any application for an intensive livestock operation for its effect on water quality. Mr. Etchegaray, when you deemed the application complete, were you aware that Coal Lake is the main water supply for the city of Wetaskiwin?
No, at the time that I deemed the application complete. I didn't know that.
Okay. I think I have the answer for my next question, but I'm going to ask it anyway. After you received the response from the county, did you consider the expired intermunicipal development plan in your assessment of the application?
No.
I'm going to come back to your prior answer. So when was the application deemed complete?
I think it was January 12th, 2022. Let me double check.
Three.
I believe it was January 12th, 2022.
So the letter from the county came after the application was deemed complete?
Of course, we notified them at the time the application is incomplete, okay. And then that's when we asked the county and affected party to respond. So yeah.
Okay. In writing your decision document, though, you were at that time you were aware that Coal Lake is the main water supply for the city of Wetaskiwin.
Yes, of course.
Okay. The city of Wetaskiwin does not meet the requirements for an affected party under the legislation, but the city did submit a statement of concern to you during the referral period for the application. Did you consider that statement from the city in your assessment of the environmental risk posed by this proposed operation?
No.
And why was that?
Because there's no directly affected party. I received 26 other letters, including the city of Camrose, and I didn't consider any of those responses.
The city indicated in its letter that it's opposed to any operation that would increase the nutrient load on Coal Lake. During your review of Darcor's application, did you reach a conclusion as to whether the operation would materially impact nutrient load on Coal Lake?
I assessed the impact of the CFO and the CFO facility into groundwater and surface water, and those assessments were low. So we can infer that the impact into the nutrient load would be low.
And again, I think I may know the answer to this question, but I'm going to ask it again anyway. Did you provide a response to the city of Wetaskiwin regarding its concerns about Coal Lake?
No, we every time we receive a letter, we respond that we have received it, and that at the time of the decision, they will receive the decision of the decision. So, but not specifically to their concerns.
Those are my questions. Thank you, sir.
Mr. Smith, do you have any questions?
Yes, I do. Thank you, and good morning. Mr. Etchegaray, in your decision summary, you note that you used the environmental risk screening tool to assist in the assessment of the risk posed by the proposed facilities to surface water and groundwater. So, Mr. Etchegaray, or perhaps Mr. Cumming, would you please describe the environmental risk screening tool and the key factors that are considered when assessing risk to surface water and groundwater?
Maybe Mr. Kamen would like to answer this one.
I'll do my best. The environmental risk screening tool is just that. It is a screening tool. It is a way that we evaluate potential risk to surface water and groundwater. Surface water risk is predominantly looked at by the pathways between wherever the CFO is and any receptor body of water. And it looks at the different types of materials that are in the soils and the type of vegetation over that pathway to come up with a determination of risk. It also takes into consideration the rainfall that could be expected in that area. But as I mentioned, it is a screening tool. It's not measuring the actual risk at any particular site, because it's based on categories of materials and categories of information as opposed to specific information at the site.
Thank you, Mr. Cumming. Mr. Etchegaray, I would like to be a little specific here and ask if you could please describe the aspects of this application that contributed to your assessment that the potential risks to surface and groundwater were low.
Of course. For surface water, we calculate the distance from facilities to the lake. And in this case, the closest facilities, which would be the existing EMS, would be a little over 300 meters. Or the other facility would be a little over the 300 meters, 350 meters. The new proposed facilities were all built out, they were proposed to be built out of concrete, which is a proper liner to protect from runoff. And the building has roof and it has walls. The lagoon, it will have berms, so that and there is a 0.5 meter freeboard to protect from overflows. And then the distance from the lagoons to the lake, in the distance there is also a little bit of vegetation, trees and grass. It's no bare land. So those are some of the factors we consider when assessing the risk to surface water, specifically to the lake.
Thank you, Mr. Etchegaray. You described the topography of this site as undulating with the western slope toward Coal Lake and a slope break adjacent to the site that creates a steep slope to the lake. how does the environmental risk screening tool address this specific type of topography with respect to surface water? And I mean the steep slope after the break.
Exactly. So there is different slopes in there, different categories of slope, like 0 to 2% slope, 2 to 4%. But in this case, the lagoon is not right next to the break in the big slope. There is about 100 meters before the big break. So I believe in this case, I consider it as a kind of worst case scenario, even from the edge of it, but because of the distance, 300 meters, it was a low risk anyways.
Thank you. And I just have one final question then. When you described your use of the risk screening tool, you talked specifically about the barns and the EMS. You weren't didn't give consideration to the pastures and the field because they were not part of the CFO?
Exactly. Yeah. Like you mean where people are going to apply manure or
manure application, perhaps having animals grazing on pastures?
Yeah, because they didn't apply for pens, which would be considered a CFO. So if they're having animals in pasture, that is no under our jurisdiction, right?
Thank you. Those are all my questions. Thank you.
Okay. I have a couple questions that follow on Mr. Smith's. The proposed facilities, as we said, are about 300 meters from Coal Lake, but the County of Wetaskiwin Municipal Development Plan has a CFO exclusion zone that's 1.6 kilometers from the lake. Mr. Etchegary, could you please explain why you assess the risk proposed by this operation to surface water quality as low, despite the significant difference in setbacks?
Yeah, we don't take in consideration the municipal development plan or any planning document when we're assessing the risk using this tool. The tool doesn't include those ones. It's just other factors.
And those other factors are what you have already described to us in our questioning?
Exactly, yes, yeah.
Okay. In its written submission for the hearing, the County of Wetaskiwin makes reference to the NRCB decision about GNS Cattle Limited. The board concluded in that situation that although the proposed site of the CFO met setback distances and other AOPA technical requirements, this is not, I'll read from the decision, determinative or indicative of the potential broader effects of the CFO and the associated manure spreading lands on the Pigeon Lake watershed community and environment. You've concluded that this application poses a low risk to surface water and groundwater. How are the potential impacts from this proposed operation on the Coal Lake watershed and environment different from the potential impacts of GNS cattle on the Pigeon Lake watershed and environment?
Yeah, I didn't consider that decision when I made my decision, but that is a feedlot. There are outdoor pens and corral, so the impact of runoff from outdoor facilities is bigger than mostly indoor facilities. In this case, 2 barns, and there is a liquid manure where the manure is contained and it has a freeboard to hold extra additional water that might get into there, right? Additionally, this is a registration site application, and I believe GNS was an approval site, so a lot bigger, and I didn't have to assess the impact into the community as part of this decision.
Okay, thank you. Mr. Kennedy, do you have any questions for Field Services?
I have no questions. Thank you, Madam Chair. Oh, I see Mr. Stepanek might have a follow-up.
Forgive me, Madam Chair, I do have one follow-up question arising from something to clarify from Mr. Smith's questioning. Mr. Etchegari, you indicated that and maybe I'm getting this wrong, so you'll correct me if I have this wrong, but the environmental risk screening tool doesn't account for pasturing of cows because pasturing is outside of your mandate under the legislation, right?
Exactly. Yeah, there are no CFOs.
Okay, but Mr. Smith also asked about manure spreading. Is that considered as part of the application? Is that considered in the environmental risk assessment?
Knowing the environmental risk screening tool is not. The application of manuring to land, the applicant needs to provide enough land to for the animal capacity that they're applying, and in this case, they did.
Thank you.
All right, thank you. Ms. Vance, does Field Services have any redirect evidence?
Just one short question. Mr. Etchegari, were you the approval officer on the GNS file?
No, I was not.
Thank you. That's it.
Okay, with that, we conclude the direct evidence from Field Services. So now we'll proceed on to direct evidence from Darcor Holsteins, Inc. Ms. Woodworth, would you please affirm the witness?
Sir, may I have your name for the record?
My name is Darren Rasmussen.
And Darren Rasmussen, do you solemnly affirm that the evidence you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
All right, Mr. Rasmussen, please proceed with your direct evidence.
May I ask one question first? And I'm sorry, it's just I'm not used to some of the procedures here.
Sure, go ahead.
Just a couple of things that came up from other questions to Mr. Etchegari. Is there a chance at a redirect and just being able to lock in a detail or two at that point?
Madam Chair, I would argue that that would not be redirect, and that Mr. Rasmussen did have his opportunity to ask questions.
It's as a result, really, of his answers to some of the panel members.
Madam Chair, if I might, the Field Services appears, they give their direct evidence. Mr. Rasmussen has the full and open opportunity to ask them questions. We don't really ever provide for a situation where we would loop back because often when questions arise from a party that follows, there may be additional questions that occur to the individual who's had and used their opportunity. So if that's your question, Mr. Rasmussen, no, you wouldn't. You do have the opportunity to present direct evidence, and that may be may in part answer the questions or address the questions that you have by evidence that you introduce. And then, of course, you get an opportunity in your final argument to speak to the evidence that's been presented throughout the proceeding and advocate how the panel should consider that evidence.
You know what, that's acceptable. I can make that work. Thank you.
Okay, very good. So, Mr. Rasmussen, please proceed with your direct evidence.
Admittedly, I actually have little direct evidence. I just, so much of this is boiled down to timing for me. When the application went in, and I would like to correct one little part from the previous, I believe it to be an absolute honest mistake. The deemed complete and posted in the newspaper was January 12th of 2023, not 2022, because the application went in the fall of 22. We're just getting snowed under with paperwork, so that's an honest mistake. There's a couple omissions from earlier that I'd like to comment on in my direct evidence. And that comes with evaluating risk, particularly, of course, with this application. A couple of things did not get brought up during that, and a couple of things did. Pasturing is one. This was always, and I'd indicated it to field services at the time, that there was no intent for any pasturing anywhere on this. That's why it was omitted. It wasn't omitted so much as purposely left off, because it simply did not apply to this application. This is a barn, and a barn only. Modern dairy cattle in this climate are kept inside constantly in the type of operation that I was proposing. Currently, except for dry cows, which would be held in my old facility and not at this new one, there is no cattle outside ever. So couple other things I would like to point out. Under the old MDP, which is obviously the one that is applicable at the time of the application, the county did allow for expanded CFOs within the exclusion zone, but not new. That was the whole reason behind the first request for review, was to determine whether or not there was an existing one there or not. Quite obviously, it was deemed that there was an existing permit in place at the time, which makes some of the arguments somewhat moot. Also not noted earlier, with request to manure spreading, I have approximately 200% of the land required for this barn when it is at its maximum levels. The acres involved are not even close, and they are set back considerably from the lake. Part of this application, like sorry, I don't have the whole number, I think it's 22027, actually has the piece of the parcel of land where the barn is at as excluded.
Excuse me, Mr. Rasmussen, if you could start back at the number of acres, because you kind of broke up at that point, so we didn't get that information.
Sorry, welcome to country internet.
Yeah, no problem.
I don't have the exact number in front of me. I believe it's the acres that I have available, and these are owned acres, is a little over 200% of the requirement. I also farm sort of with my younger brother, which gives me access if I need to manure spreading on double that again. So I just want everybody to know that acre wise, it's not an issue. And these are acres that are farther away from the lake than what this actual application is. And just in case it got garbled, the site beside the lake where I'm proposing the barn, I proposed 0 manure application on that land. With animals inside in a facility like this, 100% of the manure, 100% of the time is caught and contained. With no animals outside, 100% of them inside. It is literally every drop every day of the year that is caught. There was a couple other omissions when questions were coming in for evaluating the risk to the environment. Something not noted previously was that I was proposing a synthetic liner on this lagoon, which is a significant enhancement. It is actually also redundant because at the suggestion of Mr. Echegaray, I agreed with him, and I also ran a soil engineering report. Specifically, I engaged EnviroWest Engineering, and it cost me many dollars, but they did a soil engineering report and didn't even believe that I needed the synthetic liner, and yet I still kept it in there. So not only was soil engineering done, it was enhanced with the synthetic liner. You know what? That is most of what I got. My large issue with this is that, again, I tried to jump through all of the proper hoops and go with this. I feel that very much I was singled out. And when we get to some of the county information, I hope to bring that up. But I believe that this application was not handled by some of the parties as typical as it should have been. And but really, as far as direct evidence goes, that is a very tough thing, of course, for me to prove. But we'll go with some cross-examination later to help make that point. So that is all I have right now, Madam Chairperson.
Okay, thank you, Mr. Rasmussen. So now it's an opportunity to ask Darcor questions. Field Services, Ms. Vance, do you have any questions for Mr. Rasmussen?
I do not. Thank you.
Okay, thank you. County of Wetaskiwin, Mr. Chipley, do you have any questions?
I have no questions for Mr. Rasmussen at this time, Madam Chair.
Okay, thank you. And now the board panel. And this time we'll start with Mr. Smith. Do you have any questions?
Yes, I do. Thank you, Madam Chair. Mr. Rasmussen, Section 11.6.3 of the 2023 County Municipal Development Plan prohibits new or expanding confined feeding operations within 1.6 kilometers of Coal Lake. Section 11.6.4 of the Municipal Development Plan states that notwithstanding Section 11.6.3, it will support upgrades and or expansion of existing CFOs where there will be improved manure management and or mitigation of negative impacts on surrounding land uses and the environment. And you've already alluded to some of these points, but would you please explain how the proposed facilities and manure management plan represent upgrades to the current existing CFO that will improve manure management and mitigate negative impacts on surrounding land uses and the environment?
Well, the one thing that they both have in common, the existing one, of course, was 4 hogs that had a variety of facilities in it. Both of them would have had 100% containment 100% of the time as far as animals being kept indoors. That said, the new application, of course, with the modern standards, all of the concrete is sealed between pours. All of the concrete involved is of a much greater grade. It has acid resistance to prevent or breakdown over time. The sealing technologies of all of the pipes coming in and out are significantly enhanced. You have to have butyl or some version of butyl seals that didn't exist in the past. And the big thing is the lagoon, the HDPE, high density polyethylene, that stands for liner on it. Significant enhancement of what was there. And the fact that the old one simply grandfathered in when soil testing wasn't a concern. This one has full soil testing. The engineers came out. We had to do. I can't remember the proper name of the test, but it's in the support or in the report that was submitted. Water conductivity test, some version of that, and yeah, the soil. In addition, they take soil samples. That soil samples is taken or is sent. I believe it's out of province. Don't quote me on that, but I think that's the case. To a specialized lab where they conduct, I believe it's hydraulic conductivity, they call it. So yeah, they're not even in the same ballpark in my mind. We're from the old to the new.
Thank you. And I believe you addressed this point, but I just wanted to give you the opportunity to confirm it for the record. In the submissions for this hearing, we have seen concerns expressed about increased nutrient loading in Coal Lake, potential runoff to the lake from pastures or pens where animals might be kept outside at the site. You have said that you have no intention to house dry cows or replacement animals outside at this site?
That is correct. When in building this barn, the one thing that I'm left with is my old barn empty. And that's at a site 1.5 miles away. And my plans are to modify, basically just change the stalling inside of it, and that barn will house all of my the dry cows and the young stock.
And your plans would be to house the calves at the other site, at your older site?
This application did have for a small calf barn to be built with it.
I see.
The baby calves, when they're on milk, it's just so much more convenient, of course, to have them close to the milk source.
Mm-hmm. So there is some pasture around, I believe, is there at the site? And since you won't be using it for any animals associated with the CFO, would you have other plans for the use of that pasture?
Well, currently, because there's no barn there, currently in the summers I do, well, this last summer I have 17 head that were up on the top of the bank. That is a flat bank up on the top. There was none on the slope of the bank itself.
And those animals in the pasture are not using the lake for water?
No, they are not.
Okay.
Yeah. Yeah, they have no access to the bank. Sorry, just to clarify, they have no access. Where I had them this last summer, there was no access to the bank itself or the lake. It was strictly up top, and that's the piece that would disappear and become a building with this application.
Thank you. So with the upgrades and the plans that you are proposing, do you believe that this application would meet the requirements of section 11.6.4 with respect to upgrades, and therefore that the prohibition on expanded CFOs from section 11.6.3 would not apply to your operation?
Truthfully, I find 6.3 and 6.4 are very contradictory to each other. Yeah, it is absolutely a significant improvement over what is there.
And so 6.4 talks about supporting upgrades notwithstanding 6.3. You're proposing that that's where your operation would fit?
Exactly. If the county were serious in their MDP about supporting upgrades, they should be supporting this application.
Thank you, Mr. Rasmussen. Those are my questions.
Mr. Stepanek, do you have questions for Mr. Rasmussen?
I have a few. Thank you, Madam Chair. Section 11.65 of the Municipal Development Plan states that the county will consider CFOs that are located within the setbacks listed in 11.6.3, which have been operating for 10 years or more, to be without authorization to resume operation or expand, and the county will not support resumption or expansion of these operations. In Darcor's written submission, you stated that this section of the plan demonstrates direct bias against the operation because Councillor Lynn Carwell, who is a neighbor of the operation, opposes it and did not recuse herself from votes affecting the proposal. When was Darcor's perception of conflict of interest by Councillor Carwell first raised?
So when this application was filed in November and December of 2022, prior to that, the county had a number of open houses with information on the new and proposed MDP, which is of course the one we're reading out of at the time. At the time of the application, of course, it was the existing MDP that was in place. And those clauses, first of all, not in there at the time. At the open houses, there was no indication whatsoever of anything like 11.6.5 of the new MDP, or I don't know if you want me to refer to that or the April of 23 MDP. That's where I'm going with that. Anyway, there was no indication of any such thing with anything regarding CFOs not currently in use. In January, late January of 2023 is the first that this appeared, which is of course 2 weeks after my application appeared in the newspaper. So when I got looking through it, and it's not the absolute most scientific thing because there's not the tools necessarily available to me, but on the NRCB website, it has a moving map display of all of the registered CFOs in the province. I took the list of lakes that you can find in 11.6.3, plotted them all out on a county map, and then used the NRCB maps, and there was exactly 1 point of overlap between the two. Myself. That combined with the fact that, and of course, sorry, I should backtrack. 11.6.5 only applies to CFOs that are already existing and within those limits. So when you combine that with the fact, and I just find it more than suspicious that when the letters came out opposing my application, many of them cited the fact that this operation hasn't been in use for 10 years. And all of a sudden the county has a rule or a proposed rule in January that suddenly that same 10-year number came up. I can't help it if alarms are going off in my head a little bit about that. So that's really where it first became apparent to me. Of course, by that time, there had already been some grossly one-sided articles in the newspaper that quoted Councillor Carwell. So I'll be honest, it got a little personal, and I found that just the bias was significant. And I don't have the exact dates, but it would have been January or February, be late January, early February of 2023. I attended a council meeting where I indicated that I was not happy with the treatment that I was getting in the public forum. And I raised the question of conflict of interest with county council at that point. There was not agreement from them on that with me, but it was raised nonetheless. I also raised issues that I felt that she had violated a number of code of conducts. And I asked them that type of behavior would need to stop. To the best of my knowledge, though, she was not excluded from any voting, and didn't voluntarily recuse herself from any voting. That's I think the best answer I can give you.
So a question in follow-up. So at that council meeting, when you raised it, you didn't give evidence just now about this, but in your submission, you say you were told that the assertion of conflict of interest wasn't relevant. So who said that? And were you given a reason as to why it wasn't relevant?
That response came from the Reeve, and his the reason that he gave for it is that they call conflict of interest, or they believe there can only be conflict of interest when there is dollars and cents involved. There are financial implications involved.
If Councillor Carwell had recused herself when you raised this with council, how can you be sure it would have made any difference to the final municipal development plan?
County of Wetaskiwin has 7 councillors. So any particular councillor carries, of course, a significant percentage of the vote. So I base that on a few things. First of all, especially as soon as I hit the paper, I contacted 3 other councillors who all expressed backing for me. That was part of it. The other part was a vote that I witnessed in council. And on the day that I was in there to present, if I can remember this correctly, it was to do with the minutes of the previous meeting. And I don't know if you find it relevant or not, but they had discussed this application in a meeting. Immediately after the meeting is when the article came out in the Wetaskiwin Times newspaper that quoted Councillor Carwell. But what they had discussed at that first meeting had not been passed in the minutes of a subsequent meeting yet. Like the newspaper article occurred in the middle. When it came up with me in the crowd waiting to speak at that meeting, Councillor Royakers actually suggested that as it was presented in the minutes, she goes, that is not exactly what we were discussing. They couldn't agree, quite frankly, on exactly what it was that they were discussing, and their remedy or their actions because of it. The vote to pass the minutes was 4-3, and obviously with Councillor Carwell voting. The 3 that expressed backing to me in private before that all voted no to even passing the minutes that day. With the minutes passed, there was no opportunity for any further discussion for that to get opened back up again.
Okay, putting aside your concern with the involvement of Councillor Carwell, I'm curious as to whether it's your view that it would be generally improper for a municipal development plan provision to be driven by a specific case. Do you have a view on that?
I absolutely think it's improper. Yeah, no, I absolutely think that's not proper. And something that, and actually come out of my first request for review, when it back to the possible abandonment of the old one. I may even have been you that asked it, and I would like to proactively bring it up that I do have a second application in. I'm actually not going to build at this site. I will be building at the second site. And it came down to, well, at the time, I couldn't answer your question properly because you asked me why that second site was there and what was going to happen. And at that point, I didn't really know. But I'll say now that like we're building at the second application site, not the first, which of course brings up the question as well as to why I'm proceeding with this. But it goes to exactly what you just asked now. It comes down to principle. Like I'm here today because I think I got a raw deal, even though it doesn't end up changing anything for me. I'm here today standing on my principle because I think that there has been some very improper treatment there. 11.6.5 applies to me and me only for all in the past and all in the eternity, because that's the only person it can apply to. That coupled with the timing of it is because of this application and this application only. So yes, I do think it's very improper.
So I want to be crystal clear on this, sir. So you're saying that you're going to be building at the alternative site and not at the site that's the subject of these proceedings, regardless of the outcome? Have I got that right?
Yes. And I apologize to everybody for the amount of time that I'm using up on some of this. When the initial response to when I received the initial response back to this RFR, and I thought this should be fast because I thought the timing of it all should just mean that, you know what, if it wasn't for the mistake with declaring the old one abandoned, I must admit, I really thought that I would have in no time flat, a fast written response to this saying, yes, you're right. Without that mistake, this would be done and gone, because it would have been finished before the new MDP was in place, and it's all irrelevant. When I read your guys' response to that, and mainly with the questions, quite frankly, 100% of the questions directed at the county, I thought to myself, well, you know what? I'm not the only one seeing that this is just odd. And yeah, I've done a little bit of soul searching here as to waste everybody's time or not. I think any time that you're backing a principle, it's not a waste of time, which is quite frankly exactly why I'm here today.
Okay. Thank you, sir.
Before I get into my questions, I think this probably would be a good time for a break. I have it at about 10:48, and I would suggest that we break until 11 o'clock, and then we can resume questioning Mr. Rasmussen. So panel, if you'd please go into our breakout room. All right, it's 11 o'clock, so we will resume the hearing. I have reviewed the questions I was going to ask Mr. Rasmussen, and he has actually already answered them in his testimony. So I have no further questions. Mr. Kennedy, do you have questions for Mr. Rasmussen?
Madam Chair, I do not. Thank you, Mr. Rasmussen. Thank you, Madam Chair.
All right, we'll move on to direct evidence from the county. Ms. Woodworth, would you please affirm the witness?
Sir, would you please state your name for the record?
Jeff Chipley.
Sir, do you solemnly affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth, so help? No matter what.
I do.
Forget this. Thank you.
Okay, thank you. Mr. Chipley, please proceed with your direct evidence.
Yeah, thank you very much, Madam Chair. I will try and be as brief as I can to afford the board time to ask questions, as well as Mr. Rasmussen and NRCB Field Services. With the written submission that the County of Wetaskiwin has submitted to the NRCB for their consideration, we lay out the timeline from our perspective quite clearly as to our perspective on the matter. With that, just to highlight a few items is on when we first received notification back in November of 2022 from NRCB Field Services, we did ask the question through our Senior Development Officer, Mr. Jarvis Grant, as to whether it was the view of the NRCB as to whether this application was for a new CFO or an expanded CFO. And at the time, the information we received was that Field Services viewed this as an expansion/amendment to a previous approval, going from the hog CFO to the dairy cow CFO. With that, when we did receive the correspondence on January 12th of 2023, administratively, county administration was going to provide their submission as we're entrusted to do by county council. Further to that, a notice of motion was filed by a county councillor, as is indicated in our correspondence. And at the January 24th, 2023 council meeting, council did unanimously resolve to direct administration to state to the NRCB that from the perspective of the County of Wetaskiwin, we viewed this application as a new CFO rather than an expansion of a CFO. That decision by council was made in accordance with our previous MDP, so the MDP that I believe was from 2010, and we were viewing it as a new CFO, and as such, we believe that the exclusion zone of our previous CFO of our previous MDP also would apply, and that exclusion zone for new CFOs has not changed from the previous MDP to the MDP that was adopted in 2023. Mr. Rasmussen did refer to the minutes that were presented at the February 7th, 2023 meeting. At that time, council did endorse the minutes. There was a resolution carrying those minutes, and as such, administratively, we have to follow the direction of council, and based on the minutes being approved, the direction is that council views the application as a new CFO. In terms of details as it relates to conflict of interest or pecuniary interest, just as a note for the NRCB board, the Municipal Government Act does not contain any sort of particulars as it relates to conflict of interest explicitly, but rather pecuniary interest. And with pecuniary interest, that's in terms of if someone or their immediate family is benefiting monetarily, that individual elected official has to declare such pecuniary interest. It's not up to county council nor county administration to declare that person invalid. It's up to that elected official to declare that pecuniary interest, knowing that if they do vote on a matter that they do have a pecuniary interest on, there is an ability for the matter to be dealt with through the courts to potentially disqualify a councillor. But in short, the position of the County of Wetaskiwin respecting this matter, based on the direction we received from council, is regardless of it being our current MDP or our previous MDP, the County of Wetaskiwin views this application as a new CFO application, which is in contrast to what NRCB Field Services has outlined. And as such, we believe that our exclusion zone should apply and that the application should be denied. Happy to answer any questions that the board may have or any other parties. Thank you.
Thank you, Mr. Chipley. So now is opportunity to question the county, and we'll start with Field Services.
I have no questions. Thank you.
All right, next will be Darcor. Mr. Rasmussen, your questions for the county.
Yes, I have a question. The MDP that was in place prior to April of 23, did it have any indications in there as to expanded, or was there any wording in there about expanded CFOs?
Yeah, to answer Mr. Rasmussen's question through the chair, the MDP, the previous MDP, did not have explicit reference to expansions. It talked about new CFOs within a mile of Coal Lake being part of an exclusion zone. So since there was no explicit reference to expansion, the expansions would be allowed in that exclusion zone. However, when the matter was brought forward to council on January 24th, council took the position that the application as it was submitted and presented to the county through NRCB Field Services, they viewed it as a new confined feeding operation application.
At this stage, the county was aware, of course, that there was an existing CFO permit attached to that land, correct?
Through the chair, to answer Mr. Rasmussen's question, yes, and council was fully informed of that. That's part of the reason why we asked for the clarification back in November of 2022 from NRCB Field Services to get a sense of, is this a new application or is this an expansion? To which we received information it was an expansion. As such, we knew that the permit was in place for the HOG CFO.
And of course, you're aware, the council is full council aware that the CFO permit for that was initially deemed to be abandoned and has now since been confirmed by this board that it was not abandoned.
Now, through the chair to Mr. Rasmussen, council has been fully apprised of any sort of correspondence or any sort of decisions of the NRCB. They are fully aware that that the previous ruling from the NRCB related to the cancellation was that the cancellation did not occur and that the HOG CFO permit still remains in place.
With respect to Councillor Carwell, could she have voluntarily recused herself from any voting on things to do with this application?
Through the chair to Mr. Rasmussen's question, in accordance with the Municipal Government Act, the Municipal Government Act speaks to pecuniary interest. The Act is also quite clear that unless a councillor has a pecuniary interest or under certain circumstances, such as they miss a portion or all of a public hearing, they are required to vote as an elected official. Now, by all means, if a councillor were to have some sort of medical emergency or was outside of council chambers during a vote, by all means, they wouldn't vote in that circumstance.
That's all the questions I have at this time. Thank you.
Thank you, Mr. Rasmussen. Board panel and Mr. Stepanek, do you have any questions for the county?
Yes, Madam Chair. Mr. Chipley, I note the written submission refers to this January 18th, 2023 notice of motion filed by Councillor Carwell, and then that motion being taken up at the January 24th, 2023 Council General Meeting to respond to the NRCB referral. Is there anything unusual about that? Would normally administration just respond to this type of referral as opposed to council becoming involved and directing administration to respond in a specific way?
So through the chair to Mr. Stepanek, this is something that councillors do have the ability through the county's procedural bylaw to file a notice of motion. You are indeed correct that typically when we receive a referral from NRCB Field Services, that administratively we would respond based on the relevant planning documents of the County of Wetaskiwin, particularly our municipal development plan as well as our intermunicipal development plans with parties. However, with this one and with previous NRCB referrals, there have been notice of motions brought forward by councillors to discuss the matters more fulsome and provide additional direction to administration. For example, the matter involving GNS cattle, the same thing did occur where a notice of motion was filed by a councillor and subsequent direction was given by council to refer to the NRCB. The exact same thing happened here, just based on the public interest in relation to this matter as well.
Thank you. So I know this was a decision of council and not administration. With that said, are you able to explain why the county consider this to be a new operation when there's an existing registration for a CFO and existing facilities at the site?
Through the chair to Mr. Stepanek, I can't fully speak for council because council is the one that makes the ultimate decision on it. I was there when council did discuss the matter in open public forum. Some of the matters that were discussed at the time, which were contained within the notice of motion, is the length of time in which the CFO, based on commentary from the public, was not in operation. Also, the discussion as it related to you're going from hogs to a different type of animal being dairy cows. So that was another discussion of council. The topic also did come up based on feedback we'd heard from members of the public of the CFO being near the water source of the city of Wetaskiwin, knowing that the Battle River Watershed Alliance also had concerns and was in the process of developing a communique. Those were some of the things that came as a part of council's decision, where they saw, hey, we view this as a new CFO rather than as an expansion.
Do you have any other comment beyond your answers to questions so far about the allegation of conflict of interest on the part of Councillor Lynn Carwell, or have the evidence you've given already covered that?
Through the chair to Mr. Stepanek, in terms of any of the correspondence from the County of Wetaskiwin or that the County of Wetaskiwin is privy to, none of that correspondence came directly from Councillor Carwell. It was directed by council as a whole. With that, yes, Councillor Carwell does own property on the west side of Coal Lake. However, she does have the ability, no different than any other citizen in the County of Wetaskiwin, to make commentary to quasi-judicial boards as a private citizen.
Okay. Was 11.6.5 of the municipal development plan directed specifically at Darcor's application?
Through the chair to Mr. Stepanak, no, it was not. With that, I know kind of the time frame on this is the discussion related to the Darcor application was done on January 24th of 2023. At the January 26th, 2023 Planning and Economic Development Committee meeting, which is comprised of 3 councillors appointed by council, which includes Reeve Bishop, Deputy Reeve Roy Akers, and Councillor Adair. At that time, the committee directed administration to place into the draft document section 11.6.5 about the 10-year period. With that, we followed the direction of the committee and inserted that in. When the MDP was considered for first reading by council at the February 21st, 2023 meeting, council unanimously passed first reading with that section in it and sent out the MDP for referrals in advance of the public hearing, which was held on March 28th. Once the public hearing was held, council passed second reading on March 28th, and then subsequently at the April 11th, 2023 meeting passed third reading with that section in.
This is a bit of a hypothetical question, and if you're concerned about the question, just let me know. Is there anything improper with an MDP provision being informed by a specific situation?
Through the chair to Mr. Stepanak, that's not my stance to provide. That's council to make that decision as to what they believe provisions in an MDP should be in the best interest of the county as a whole. Council has resolved through the passing of the bylaw. They believe that section regarding abandonment is something that they wish to have in the county's MDP in order to have it whenever the NRCB asks for referral from the county regarding not just this matter, but any matters as it applies to CFOs or anything under the purview of the NRCB.
Your submission refers to the communique from the Battle River Watershed Alliance. The communique is dated January 27th, 2023. When did the county become aware of the communique?
We formally, through the chair to Mr. Stepanak, we formally received the communique from the Battle River Watershed Alliance on January 27th. However, prior to that date, we were fully aware, based on commentary from members of the public and information that we had heard verbally from the Battle River Watershed Alliance, that they were developing a response to the application made by Darcor Holsteins.
What specific actions taken by the county up to and including adoption of the new MDP on April 11th, 2023, were influenced by the communique?
In terms of the communique, at any sort of council meeting, the communique did not come up in discussion nor was presented in a council meeting. From the time that first reading was provided on the MDP, there was very little change to the MDP other than just the odd grammatical error that was within the document. But the overall intent of the MDP from when it was provided first reading on February 21st to its passing on April 11th did not materially change.
Your submission suggests the communique indicates that the application does not follow best practices and recommendations from the perspective of watershed management. Are you able to direct us to the specific statements in the communique that you're referring to?
With respect to the communique, through the chair to Mr. Stepanuck, just quickly find that.
We can put it up if it would help. It's part of Exhibit 15.
Correct.
The third document in Exhibit 15. Perhaps the document managers could put that up.
Yeah, in terms of that commentary related to the Battle River Watershed Alliance's communique, when you look at the entire document from an overall sense, it refers to Coal Lake being the water source of the city of Wetaskiwin. It talks about the manure application within the affected drainage area. Basically, that reference was in relation to the whole communication as a whole, and that the Battle River Watershed Alliance has concerns as it relates to the application. But in terms of actually getting down into specifics, our submission did not indicate any of that.
Thank you, Mr. Chipley.
Mr. Smith, do you have any questions for the county?
Yes, I do. Thank you, Madam Chair. Mr. Chipley, as you're aware, the request for review decision from this board spoke about considering the provisions of the municipal development plan in terms of rationale, reflective of good planning, links to planning objectives, potential conflict with the AOPA objective of common rules for siting of operations in the province. I know you weren't the person making decisions on them, but you were aware of the discussions and were privy to some of the discussions about the development of the municipal development plan. My questions are going to be addressing those points. So the 2010 municipal development plan created an exclusion zone for new confined feeding operations around specific lakes, while the 2023 municipal development plan created an exclusion zone for new and expanded confined feeding operations around specific lakes. Would you be able to please explain the rationale for the addition of expanded CFOs to this exclusion zone?
Certainly, through the chair to Mr. Smith's question. In looking at best practices, when we did do our review and update of our municipal development plan alongside our consultant Municipal Planning Services, which is a regional planning firm out of Edmonton, Alberta. In looking at other municipal development plans throughout the province, a lot of them do talk about exclusion zones, not only for new CFO applications, but also those expansions. When we looked at the county overall, we looked at, okay, what would be the best sense to protect our water bodies, specifically in relation to water sources for various residents. We did know that we do have our IDP, albeit expired with the city of Wetaskiwin, but we understand that that Coal Lake is the water source for the city of Wetaskiwin. We do know that some of our other lakes within the county that also have the same exclusion zone are essential for the various residential uses around there. So we looked at it and said, hey, adding expanded to the exclusion zone, not just new, but also expanded, would make sense. Now, we did have that additional provision within the MDP added that, hey, we're not saying completely no as it relates to expansions, as long as they are meeting an upgrade or exceeding provisions. So with that, there's kind of that caveat to the expansion area within the exclusion zone. However, with respect to this exact case, the county, through council's direction, views it as a new CFO application.
Yes, thank you. Further to that question, when a CFO exclusion zone is created, it's possible for new operations to meet the setbacks by building in a location outside the exclusion zone. When an exclusion zone applies to expanded operations as well as new operations, those existing operations within the exclusion zone are not able to expand, even when conflicts with surrounding land uses and negative impacts on the environment are minimized. Would you say that this is reasonable and reflective of good planning practice?
Through the chair to Mr. Smith, yes, and from the perspective of the county, this has been shown in many other municipalities, as has been indicated within our written submission.
Well, thank you. So do you think that people operating CFOs, existing CFOs, are entitled to a reasonable expectation that they will be able to expand the CFO if the planned expansion meets the requirements of AOPA?
Through the chair to Mr. Smith, the MDP is clear on that, and I will just reference the exact section, is notwithstanding section 11.6.3, the county would support upgrades and or expansions within that exclusion zone where upgrades in technology and or practices resulted in improved manure management and or mitigation of negative impacts. So in that case, if they're meeting or exceeding any requirements from the NRCB, who is the ones that make the decision on that, the county would be supportive based on our MDP.
Thank you. So this is one of the objectives in the municipal development plan, which is minimizing conflicts with surrounding land uses. Can you explain, please, why the municipal development plan requires larger setbacks from urban areas, acreage policy areas, and lakes than is provided by the minimum distance separation calculations in AOPA, and as are referenced in section 11.6.2 of the municipal development plan? Why does that require larger setbacks than would come from minimum distance separation calculations?
Yeah, so through the chair to Mr. Smith, based on those additional exclusion areas, it's looking at what other municipalities have in terms of their exclusion zones. The very much so in terms of the mile away from named lakes was more so to protect those water bodies moving forward based on the information that we saw from other MDPs throughout the province, as well as information that's presented by various watershed associations and alliances. In relation to setbacks from any city, town, village, summer village, hamlet, school, or hospital, that was just once again following what's common terminology throughout the province that we were able to find through our research from those standpoints. By all means, we do our best to keep to what AOPA says, but there are areas in looking at our best practices throughout the province for these areas of exclusion zones that county council saw, hey, we could have these additional exclusion areas based on what other municipalities are doing in the province as a best practice and as recommended by our consultant.
Thank you. In your municipal development plan, there are lake policy overlay lands identified, and the lake policy overlay lands for conservation lakes, such as Coal Lake, are lands within 0.8 kilometers of the lake, while the setback for the CFO exclusion zone is 1.6 kilometers from the lake. On developed lakes, the policy overlay lands and the confined feeding operation exclusion zones are both set at 1.6 kilometers from the lakes. Can you please explain why there is a difference between the distances of the policy overlands and exclusion zones for conservation lakes, but no difference for developed lakes? I'm curious as to why there is this difference.
Yeah, so through the chair to Mr. Smith, in terms of the conservation lakes, the reason why the distance was shrunk to that half mile or 800 meters is because there's not as much development within those lakes. The potential to actually have a confined feeding operation in those areas is a lot smaller than the potential that we see around developed lakes, such as Pigeon Lake, where where we had the GNS cattle matter, or Coal Lake, where we have this matter in front of us. With that, in looking at those various lakes, such as Pigeon Lake and Coal Lake, the previous thing for new CFOs was put at that 1.6 kilometers. Yeah, it was more so knowing that those lakes are going to have a higher intensity of development around them. For example, Coal Lake being the water source of the city of Wetaskiwin, knowing there's residential development there. Same thing for Pigeon Lake, knowing there's residential development in other municipalities around that lake. Buck Lake, because it is a hamlet within the county with a lot of residential subdivision. Whereas where you look at some of the conservation lakes, such as Battle Lake, Twin Lakes, Town Lake, there's not a lot of development around those areas, nor are we expecting any sort of future increase in development around those areas.
Thank you, Mr. Chipley, but just to be clear, in your municipal development plan, Coal Lake is considered a conservation lake, not a developed lake.
My apologies.
Just for clarity, yes.
Yeah.
I have no further questions. Thank you, Madam Chair.
I have a few questions. Mr. Chipley, your submission refers to best practices in watershed management as informing the MDP. What specifically has been said about 1.6 kilometers as the recommended setback distance? And what I'm wondering is, what is the basis for that distance, and why isn't it greater or shorter?
Yeah, to the chair, in terms of that distance, that's just based on the distances that were in our previous MDP as it related to new CFOs, as well as from what we've seen in other municipal development plans throughout the province. That 1.6 kilometer number tends to come up a fair bit in terms of buffer zones or exclusion zones. So that's the number that council decided to go with.
Do you have any comment on whether this is consistent with the AOPA objective of establishing common rules for the siting of CFOs across the province?
Through the chair, in terms of our commentary as it relates to whether the MDP is in conflict with AOPA and common rules, the provisions within our municipal development plan are consistent with the provisions that a large number of municipalities throughout the province have placed within their MDPs as it refers to exclusion zones. For note, Ponoka County has exclusion zones as it relates to various things within their documents, and the courts have found that those exclusion zones are well within line. With that, the county isn't the one that has to ensure that the provisions of AOPA are adhered to. However, it's the county's responsibility to provide good government and maintain the fiscal environment as outlined in the MGA. And by putting these provisions within our MDP, it's council's stance that these provisions are doing what's best under the MGA for our municipality and have been placed in the MDP so that when the NRCB comes for referrals, administration does have direction as set forth by council to provide to the NRCB rather than having every single matter come before council on these situations.
So is it the county's view then that the AOPA prescribed minimum setback distances from a common body of water are insufficient for this proposed CFO from Coal Lake?
Through the chair, based on our MDP, the stance of the county would be yes.
What environmental protection or other benefits are provided by a 1.6 kilometer setback that would not be provided by an operation meeting or exceeding AOPA requirements for protection of surface water?
Through the chair, with respect to the distance being further, as has been outlined in documents such as Battle River Watershed Alliance's communique, talking about the length of time for drainage into a water body, looking at how the various runoff would take a longer amount of time based on that 1.6 kilometers away from the water body rather than the AOPA distance, which if I recall, it can be as small as 30 meters in areas. It just provides for that more time for effective drainage and for the natural environment to do its thing and take its course and deal with any sort of contaminants prior to them getting into a water body.
So now I'd just like to refer to your MDP 11.6.5, which talks about the 10 years that we've been discussing previously. Can you explain why a CFO that has not been in operation for 10 or more years should be treated differently than one that has been in operation?
Yeah, through the chair, the perspective of the County of Wetaskiwin on that one is with a CFO that hasn't been in operation for a decade or more, rules, requirements, regulations, best practices change over time. And from the stance of the county, having a operation be abandoned for a decade or more, there is now an opportunity for best practices to potentially be updated. For example, the county, as it relates to other sorts of developments within the county, we only have area structure plans. If work isn't commenced on an area structure plan within 3 years, we make individuals go through the entire process again, just based on rules and requirements and best practices changing. So that 10-year period is just that sense of after 10 years, rules, requirements, regulations, best practices may have changed. And so it provides that opportunity of having an application be revised to reflect those.
Is it possible as well, and this was just a thought, that 11.6.5 also may exist because if an operation hasn't been there for 10 years, some of the land uses surrounding the operation may have changed?
Yeah, through the chair, absolutely. Some of the land uses around the area may have changed, and that also provides an opportunity to look at, hey, is this operation the best from a planning perspective within the area?
And for this CFO, were there any land use changes that could possibly cause conflicts arise after the operation ceased? Are you aware of any?
Through the chair, there has not been.
And can you tell us why 11.6.5 only applies to CFOs within the 1.6 kilometer setback distance and does not apply to CFOs generally in the county?
Through the chair, with respect to section 11.6.5, it applies to anything within those setback areas. In a sense of those CFOs, it leads to that whole new CFO versus expanded CFO. From that standpoint, by all means, if something is outside of the exclusion zone and wishes to expand, we have no concerns with that because new and expanded CFOs are allowed outside of the exclusion zone. This is in relation to those CFOs that are in an exclusion zone that haven't been operated in a decade, that Okay, now they want to expand or they want to change what they're doing. Now, well, after 10 years, we believe that they need to look at, okay, what are the best practices? Is it the best fit for the area? Has there been changes?
Okay, so I understand your reasoning why those within the 1.6 kilometer setback distance may need to, but do you have any, again, do you have anything else to add as to why that 10-year time period would not apply to CFOs that are outside of the 1.6K?
Through the chair, in terms of that 10 years not applying, it's simply due to the fact that the county would have no concerns outside of those exclusion zones, whether that CFO is expanding or is brand new. The county has no concerns and in fact supports the development of CFOs outside of those exclusion areas.
Okay, thank you. That's all for me. Mr. Kennedy, do you have any questions for the county?
Madam Chair, I do have a couple of questions. And Mr. Chipley, they relate to 11.6.4, which is the notwithstanding the provision not allowing expansions, you might be able to do so if you improve environmental considerations, and that's may not totally capture that provision, but it really requires an assessment by the municipal council or municipality as to how effective the environmental measures are with respect to the expansion. How does the county go about doing that, and what expertise do you have in-house to conduct that assessment?
So through the chair to Mr. Kennedy's question, if that situation were to come up, what the county would do in terms of their referral is look at section 11.6.7 in our referral to the NRCB and say, hey, the NRCB is the one that makes the ultimate decision on moving forward with these matters. It would be the stance of the county that an environmental impact assessment that's prepared by a qualified professional be submitted as a part of their application so that the NRCB can see that there has been enhancements based on the rules and regulations of the NRCB that would meet the intent of section 11.6.4.
So let's go back to 11.6.4 and assume for the moment that the NRCB would decline to do an environmental impact assessment or direct an environmental impact assessment, which might be a different beast altogether. But the county is asked to take a position whether you object to or don't object to an expansion by the approval officer. And yet, I think if I understand your answer correctly, is the county's answer would be dependent on the technical determinations made by an approval officer. So at what point are you in a position to say, we think this 11.6.4 applies or it doesn't apply, or in fact, do you defer the determination of 11.64 and say, we will let the NRCB approval officer make that determination, and if they find it meets the test of 11.6.4, please go ahead and approve the expansion?
Yeah, so through the chair to Mr. Kennedy, it'd be more so the latter, as you've identified. It'd be deferring it to the NRCB field officer, stating it's based on their determination. What our recommendation would be is that the NRCB consider the applicant submitting that environmental impact assessment to further confirm that that there aren't additional environmental impacts. In fact, there are upgrades that are helping with making a positive impact or limiting the impact on the environment from that standpoint. With that, it's us providing our commentary, knowing that the NRCB is the ones that make the final decision.
And Mr. Shepley, it leads to one more, your answer leads to one further question, and it's this, is, of course, if we're dealing with improvements to an existing operations without an expansion, I think necessarily you might say we're managing the same amount of manure, and with improved facilities, it might reduce impacts. But if we're looking at an expansion and there's no provision here that says how much expansion we might be looking at, there is the potential for the operation to have better management but increased effects. What's the county's provision as to how 11.6.4 should be applied by the NRCB or interpreted by the NRCB in that case?
Through the chair to Mr. Kennedy, the biggest thing would be looking at, is it improving the manure management from what was previously there? Is the environmental impacts that are previously there being mitigated? Are they going to be the same? Are they going to be less? Or are they going to be more? Those would be the biggest things that we would be looking for. And that's why in those typical things, we would recommend to the NRCB of taking that environmental impact assessment and showing that, hey, even though there might be increased or enhanced operations in the area, is it mitigating the negative impacts on the surrounding land uses of the environment? If it is, then section 11.6.4 would be in the positive for that application.
So just to be clear, and I want to make sure that we all understand the answer, are you suggesting that the expansion would, with improved techniques, would have to result in a reduction of the effects associated with that overall operation?
Yeah. Through the chair to Mr. Kennedy, the way in which we interpret section 11.6.4 is that it would result in improved manure management and mitigation of negative impacts on surrounded land uses. So it would be having a mitigation of negative impacts in the area from what was previously there.
And again, I don't mean to keep coming back to this, but I'm not sure that your answer is totally clear. Are you looking for a reduction or no more, no increase, and if anything, a reduction of the effects?
At a minimum, it would be no increase.
Thank you. Thank you, Mr. Chipley. Thank you, Madam Chair. Those are my questions.
Okay, Mr. Chipley, does the county have any redirect evidence as a result of the questioning?
Just to kind of summarize, the stance of the County of Wetaskiwin is that
Well, sorry, Mr. Chipley, there are closing arguments.
Okay, I'll save them until that time, Madam Chair.
Okay, thank you. Okay, so Darcor, Mr. Rasmussen, do you have any rebuttal evidence to present? Please keep in mind that if you do present rebuttal evidence, there will be an opportunity for others to question you. Sorry, you're on mute, Mr. Rasmussen.
I'm sorry, I forgot that button. Sorry, I'm in a position here where I'm looking out my window and I have somebody walking up my driveway. Could I just have a split second or 1 minute to get rid of them?
Absolutely.
Thank you. I'm sorry about that. There's some things that are just outside of your control. As far as rebuttal evidence goes, I just want to re-clarify that with respect to 11.6.4, just how much of an upgrade that a new facility would be. And just to re-clarify the fact that Rasmussen.
Yeah, sorry, Mr. Rasmussen, you're breaking up. Is what you're going to present rebuttal evidence, or would you be presenting this as closing argument?
You know, perhaps it would be best as sorry, let me just peruse my notes here just for 1 minute. Madam Chairperson, I think with a quick look at my notes, I could cover it all off in my closing arguments.
Okay, because that's what's next anyway.
Right next?
Okay, yes. Closing arguments are the next thing. What we have left on the agenda are closing arguments. You first, then the county, then field services, and then finally a reply from Darcor if you choose. And then basically just chair closing remarks.
With your permission and the fact that we're 8 minutes before lunch, could I suggest a combination of lunch and a moment for me to accumulate my thoughts?
I think that would be a good idea. I think for all presenting closing arguments, it's a good idea to have a bit of time to pull everything together. So why don't we recess for lunch? And does 1 o'clock work for everyone to resume?
Or even earlier? Yes.
Okay, we'll go 1 o'clock. So we'll see everyone back here at 1 o'clock.
Thank you.
Madam Chair, this is Laura. It looks like we're just waiting for field services.
Yeah, so I guess we'll give them another couple minutes. I'm sure they will arrive.
Yeah.
And here they are. Okay, it looks like everyone is back. So we will resume the hearing, and we're at the closing argument portion of the hearing. And first to make closing arguments is Darcor. Mr. Rasmussen, please proceed. Sorry, Mr. Rasmussen, you're on mute.
Not very good at that, am I?
No worries.
Just before I start, I'd like to say, quite frankly, thanks for the opportunity to come before you here today. I think I probably raised an eyebrow or two when I just want to say again that
Sorry, Mr. Rasmussen, you were breaking up, so if you wouldn't mind starting from the beginning again, we missed much of what you first said.
Yeah, sorry, it's just after that it started glitching here too. We'll try again. I just wanted to thank you all for the opportunity to actually come here today and to speak on this. I raised some eyebrows before, I'm sure, when I talked about the fact that there's 2 applications and what I'm doing with those. I just want to explain that I try to live by doing the right thing. And I just felt wronged on this, and that's why I continue to proceed with it. So formally, a wrong has occurred here. The way this whole application has been. When I initially started back in November of 22, which is 18 months ago now, I did know, because of the public forums, that the county was changing their MDP. My initial call with respect to this application, we're really just about timing.
I'm sorry, Mr. Rasmussen. If you can start again with you were talking about when this first began, you knew the MDP was changing, and then we lost you.
Madam Chair, I'm wondering, and I'm not suggesting for the panel do it, but maybe if some of us turned off our videos, it might have an effect on bandwidth.
And I've done all I can. I upgraded to Starlink and everything, and it's as good as I can get.
Yeah, we'll just let you know when there's problems, and because we want to hear everything you have to say.
Oh, you're back moving again, Sam. Or can you hear me now?
Yes, we can hear you now.
I wish I knew what I could do about this, but I don't. And the one piece is the new MDP would not support this application, but the existing one would, because of course, and as Mr. Chiplett confirmed, there was nothing about expanding in the original MDP. I think the phrase that Francisco used the most, Mr. Eschegier used the most, was it's the rules of the day, and particularly, of course, on the day that he's ready to make his ruling. And really, I guess that's why this whole thing has happened. That makes the county argument for the fact that they consider this application as a new application irrelevant. You can't fast forward or reverse in time to pick the set of rules that and my screen just locked up again.
Mac, is there any way we could have Mr. Rasmussen perhaps join us by phone? We wouldn't have his video, but would we be able to hear him better, do you believe?
I think if he turns off his video, it should get better quality.
Okay.
So we can hear him. Yeah.
Just the button on the bottom that says stop video.
Yeah, that's correct. Yes.
Okay, I'll hit it now. And can you, you can still hear me?
We can.
Okay, and I can see you. Let's try again. Where would you like me to start from?
I guess back where you were starting to talk about you knew the new MDP would change things.
Oh, that really didn't come through then. Okay.
No, it didn't.
Okay. Anyway, when I started this whole process 18 months ago, I obviously knew, thanks to the public consultations, that the MDP was going to be changing. So when I talked to Francisco about this particular application, one of the, much of what he talked about we talked about was timing, and the fact that on that day, the existing MDP supported this application, but when the new one came in, because of the addition of the wording expanding, that the new one wouldn't. His phrase was the rules of the day, and it is, of course, what matters is the rules of the day on the day that he makes his ruling, which, as you all know, is defined by a certain amount of timelines. So when this makes the county argument about whether they consider this a new or expanded CFO, quite frankly, irrelevant. You can't fast forward in time or reverse in time to pick the set of rules that you would like to use that day. And furthermore, I think there's a fair bit of confusion around what it is exactly that the county wants. And I don't think that the county really knows what they want. When you look at 11.6.3, according to that and only that, they should be opposing this. 11.6.4, I think I made a heck of a case for the fact that they should be supporting this application. The addition of a synthetic liner, the addition of soil engineering, the addition of up-to-date concrete types that are manure resistant. Something I forgot to mention before, this barn is going to feature robotic cleaning, like continuous robotic cleaning. Literally every drop, every day, gets contained and gets dealt with properly. Mr. Kennedy, in his questions, Mr. Chipley, went down the road of trying to get the county to quantify what it is that they're on. There really wasn't much of an answer there, though. It came back to, after about the third go-around, that it came back to the NRCB would be the making of the rules of that. The county actually has an in-house expertise called the Ag Service Board. I know for a fact, because my brother sits on it, that they're never consulted when it comes to new projects. They don't, again, I don't believe that they know what they want. Something else Mr. Chipley mentioned is that they employed the Municipal Planning Services Company out of Edmonton to help develop their new MDP. This was a part of the system that I went to with public consultations. 11.6.5 did not exist at that time. It was created afterwards, in January, February, after my application had gotten in there. When we talked about timing of the application, all we mentioned today was that it's deemed complete on the 12th of January. The county has access to that before then, or at least knows that I'm coming before then. They admitted in their thing that they had talked about, in their testimony, that they had talked and sent queries back to the NRCB in November of 22. So it's entirely possible that, especially when you have a councillor with concerns, as Councillor Carwell does, that this comes up well before the January 12th date. And I find it incredibly suspicious that 11.6.5 comes up suddenly in the narrow time frame that it did. Best practices was also mentioned time after time after time today, and yet when the county was quizzed on what best practices are, there was no real answer. It also came up with the watershed paper. What were the best practices in it? All of it is a heck of a non-answer designed to sound like an answer. That is a paper designed by a very polarized group that really only has one outcome in mind. There are so many things in that paper that all of it certainly doesn't apply. One of the things that they had talked about is, and I'm going to butcher the word because I can never say it right, fluvial streams, which amounts to spring runoff. They go on and on and on about it in there, and yet this is totally irrelevant because at the time when spring runoff is occurring, they don't even seem to know that you can't spread manure in the winter. There's no manure sitting on the top of the land. You can't get out there to spread new because really by definition, when spring runoff is occurring, your land is a mixture of either mud or ice. And you certainly can't be out there with any heavy equipment. So frankly, I think that entire document is suspect and really should bear no consequences with this finding. 11.6.7 was another interesting one. When Mr. Kennedy brought up environmental impact assessment, I believe he called it another beast. I think that's a bit of an understatement, actually. As I've had it explained to me, when you go to do something and you acquire one of those, that about $250,000 is your starting point. So I think that this is just another example of poor planning by the county, because if they start requiring that impact assessment, really you're not going to get any new agriculture, because with a starting point like that, there's not going to be a budget that really withstands that. So moving on a little bit, just to sum up, I don't want to carry on too long. Large reason why we're here today is that there's been an artificially created delay with this entire procedure. Never in my wildest nightmares would have I imagined that 18 months down the road, we still sit here. And those artificial delays have pushed this application into a new MDP when it should have been defined by the existing MDP that was in place back from November, well, all the time prior to the 10th of April, 2023. The mistake now documented by this very board concerning the abandonment or not of the original CFO permit that really I'm using to grandfather in on this, combined with the artificial muddying of the waters by a county councillor, has pushed this beyond and into the new MDP. That's something that I missed saying earlier here too, I just noticed. And it came up in the testimony from Mr. Chipley when we were talking about powers of one councillor and whether administration should be bringing things up or a councillor should. The comment was made that with enough public outcry, the councillor has every right to bring stuff up on his or her own. My question on that, when the councillor that brings this up is on record the week before in the newspaper creating the public outcry, is that still valid? The Wetaskiwin Times had a fairly lengthy article in which Councillor Carwell, and I will say councillor very much on purpose, because she's identified in that as a councillor in the paper, citing concerns, unfounded, grossly hyperbolic. When she creates a public outcry, does she still have the moral right to be the one in at council meetings leading the charge against this. So in summary, I believe a wrong has occurred. And I believe that if you're principled, that it needs to be fixed. Fixed so that nobody else has to spend 18 months of grief and stress enduring this. Thank you. I've lost your audio.
I was muted.
Your turn.
My turn. But thank you for your comments, and we did hear you. Turning off the video seemed to make a huge difference. So thank you for that. Next is closing arguments from the county. Mr. Chipley.
Thank you very much, Madam Chair. As has been outlined in the numerous correspondence that the County of Wetaskiwin has sent not only to NRCB Field Services, but also to this board through our written submission and then the additional request for information. It is the stance of the County of Wetaskiwin, as directed by County Council at the January 24th, 2023 meeting, that the county is of the opinion that this application is for a new confined feeding operation and not an expansion. With that, County Council believes that regardless of what MDP the NRCB is looking at, whether it's the old MDP from 2010 or the 2023, as it is a new CFO application, that it's within the exclusion zone to Coal Lake and as such should be denied by the NRCB. Just a couple of additional notes as a part of my closing comments for the NRCB. With respect to councillors bringing forward notices of motion, that is completely in line with the county's procedural bylaw, and in fact would be one of the main tenets of elected officials, is to represent their constituents in which they serve. With that, a valid notice of motion was submitted to council. Council as a whole made a decision to direct administration, not one councillor, but council as a whole, and it was a unanimous decision to view this as a new confined feeding operation, and as such, administration is tasked to follow the direction that is duly set forth by council. In terms of the commentary that there was statements made in the media prior to the notice of motion, I note that the article in the Wetaskiwin Times was published on February 1st of 2023, which is after the notice of motion was considered by council on January 24th. And with that, council was fully apprised of the information that was contained within that article, much of which was from the request for decision that was brought forward for council's consideration on the 24th. With that, I do also note that the one section where it talks about environmental impact assessments was a part of the draft MDP at the time that council considered the matter on the 24th of January. It's absolutely correct that the abandonment stuff was not in there until such time that council passed first reading, but the draft document did have the environmental impact assessments. With that, the county fully understands that it's within the jurisdiction of the NRCB to make their decisions in line with AOPA. However, it's the county's duty to represent its citizens through the approval of their various planning documents in the best interest of our citizens, to provide referral comments as what we would view as best for the County of Wetaskiwin. Other than that, we thank the NRCB for our opportunity to provide our perspective, and look forward to seeing whatever decision the NRCB sets forth. Thank you.
Thank you, Mr. Chipley. Field Services, Ms. Vance, do you have a closing argument?
I do. Thank you very much for the opportunity to make a closing argument. Mr. Rasmussen did speak about delay in his closing. I just wanted to remind the board that the preparation and evidence from field services was based on confined to the issue that the board had set out in its RFR decision, being whether the board should exercise its discretion under section 25(4)(g) of AOPA. And of course, if any alleged delay is going to be a consideration of this panel, I would request an opportunity to respond on behalf of field services. I don't think it's going that way, but I just wanted to make that clear. Following some of the questions posed of Mr. Etchegaray this morning, I wanted to highlight some of the legislative context that we are all sitting in today. And of course, this is, not intended as substantive argument on the issue before the board. It is intended to be in the spirit of information and background. And again, just for clarification, and if I am stepping outside of my bounds, please feel free to remind me of my bounds. So application RA22027 was for a registration-sized operation. The approval officer found the application inconsistent with the land use provisions of the county's municipal development plan. It is undisputed that under section 22 sub 1 sub A of AOPA, the approval officer was obliged to deny this application. It was not a discretionary decision. And in fact, denying an application for being inconsistent with land use provisions of a municipal development plan is a common feature for all three kinds of permits under AOPA. We've got approvals, which are the larger ones. We've got registrations, which are these not so large ones, and then authorizations, which don't involve animal increases. So requiring an approval officer to deny any of these applications in light of an inconsistency with the MDP land use provisions is common to all three. So another thing that's common to all three of these kinds of permit applications and the approval officer's task under all three kinds of applications, of course, is that the application must meet the requirements. And in AOPA, the wording is the requirements of the regulations and part 2 of AOPA. And the regulations largely are the standards and administration regulation. There's sometimes some part 2 in there as well, but that's what we sort of generally call the technical requirements. That term is thrown around, and we sort of mean the standards and regulation requirements. So while so we have these two basic rocks of any permit decision, which is one is the MDP land use provision consistency, and one is the technical requirements consistency. And once you get over those thresholds, there may or may not be more to consider. And so this is kind of where I wanted to outline some of the small, but I would say deliberate distinctions between approvals and registrations. There's sort of three ones that I would point out. One is regarding directly affected parties. In a nutshell, you have to be an affected party before you can be a directly affected party. And affected parties for each kind of permit application, you can find it in AOPA. It's set out at section 5 of the part 2 matters regulation, and also a little bit in sections 19 and 21 of AOPA. And I'll just pause at this point to say that I had asked the document manager to be ready with AOPA on Canly in case anybody wanted to look at any of these sections that I'm talking about. So I'm in your hands if you think that would be useful. But I'll outline them, and I can repeat section numbers, or I can read them out, whichever works best for you. So for
sorry, Ms. Vance, I'll just ask, would anyone, would it help anyone to have this information from Canly up on the screen?
No.
Okay, I'm hearing no's or I'm hearing nothing, Ms. Vance, so I think we're okay without it for now.
Thank you so much. So for directly affected parties, and essentially for application or for approvals, this will include neighbors or landowners or occupants within what is known as the notification radius. It may also include landowners and occupants outside of that radius if they can establish that they are directly affected by the application, which is kind of a discretionary decision of the approval officer. For registrations, it is a little bit different. To be a directly affected party, to be an affected party, in fact, you must be within that notification radius. If you own or occupy land outside of that radius, you cannot get into the directly affected party box at all. So that's one of the key differences. The approval officer in his decision summary in Exhibit 1 does sort of cover some of that. And he talks about who is directly affected. The second small but deliberate difference is the scope of submissions that directly affected parties can make. For approvals, and this is section 20 sub 1 sub B sub little Roman numeral 3, directly affected parties have an opportunity to furnish evidence and written submissions relevant to the application. For registrations, this is section 21 sub 3. People who are making submissions may make submissions respecting whether the application meets the requirements of the regulations. So the wording is slightly different. The scope of what those submissions can be is slightly different for registrations as compared to approvals. And if you want to ask me about authorizations, I would be delighted to talk about them, but they're not germane to this hearing. And finally, the scope of the task of the approval officer under AOPA differs between approvals and registrations. And that's a visual compare. If you look at AOPA as well, if you look at, and AOPA will tell us what the approval officer must consider and sometimes what they may consider. And in general terms, the approval officer is confined to what the legislation allows them to do. Section 20 sub 1 sub B of AOPA sets out what an approval officer must and may consider in the context of an approval application. Section 22 sub 1 sub B of AOPA sets out what an approval officer must consider in a registration application. And there's a laundry list under section 20 that you don't see under the registration section. And I guess my only point there is just to understand what Mr. Echegare's task was on this particular application. And finally, you should definitely take your own counsel on this point, but I would point out that section 25 likely does not limit this panel to what your considerations can be quite as much as the approval officers are. You also have a laundry list. Some of them are restricted to approvals, some are not. Subject to any questions that you may have, those are my submissions.
Okay, thank you, Ms. Vance. Okay, at this point, Mr. Rasmussen, if you wish, you may reply to the closing arguments. It's your choice.
Okay, I remembered the mute this time. Would you like me to try again with the camera, or should I just leave it off?
We're hearing you really well without it, so why don't we just leave well enough alone?
I can live with that. If it's not broke, don't fix it. Yes. I actually have very little else just to sum up. I think I've been disjointed, I know, but I believe I've covered most of most of what I needed to. One question that that nags at me just a little bit is Mr. Chipley keeps coming back to that the county considers this a new CFO. And given that I know that they haven't used in-house expertise, and I really haven't heard anything about external expertise, I wish that I had asked much more about what it is that they're using for expertise to make them think that this is a new rather than an existing CFO that is modifying and expanding. Beyond that, I think I've made the points that I want to. And again, I thank you for the opportunity to come on here today.
Okay, thank you, Mr. Rasmussen. So now we're going to proceed to the chair's closing remarks. The panel thanks everyone for their participation in this review process. Thank you to Ms. Kaminsky and Ms. Powers-Sanford, our document managers, Mr. El Hakim, our Zoom host, Ms. Woodworth, our court reporter, Ms. Friend, our manager of board reviews, and Mr. Kennedy, the board's general counsel. Your assistance has been essential to the board for this virtual hearing. The panel will consider all of the information that we've received, and we will provide our decision to all parties in a form of a written decision report. The board's longstanding performance target is to issue its decision within 30 working days, 6 weeks, of the close of the hearing. In this case, I would expect our decision will be completed within the 6 weeks. Thank you very much, everyone. This hearing is now closed.